Here's everything you need to know about public intoxication charges in Montgomery County, Texas. Howdy, my name is Brian Foley, and I'm a criminal defense attorney here in Conroe, Texas, and I represent folks who've been accused of a crime in Conroe, the Woodlands, and that general area. Today, we're going to be talking about public intoxication charges, specifically about how to avoid them, how to put yourself in the best position, what to do if you get arrested for public intoxication. And let's talk about it. We're in Montgomery County, Texas, the Woodlands, Texas. What is the most likely place for you to be arrested for public intoxication? You guessed it, it's the Woodlands waterway, leaving one of the bars around that area. I even had a client the other day who was leaving a hotel room after a conference. They're not from this area, and was fine, totally sober, but was out really late at night and was shouting to a friend who was up, just ahead, and got arrested for public intoxication. So this thing can happen really easily in that area. But there's good news. One is that these are difficult to prove. So let's look at the elements of public intoxication. So first, it's under 49.02 of the Texas Penal Code. Under public intoxication, it says a person commits an offense if the person appears in a public place while intoxicated to the degree that the person may endanger the person or another. So if you're a danger to yourself or others, that's the big deal. It has to be not just intoxicated, not just in public. You can't be if you're in the bar, that's not necessarily considered public, but they always do it after you get taken out of the bar. You're going to end up being put in public, just like, what is the tater salad, comedy skit. We've all heard that. But once you're out there, if you're out on the waterway, you're walking back to your car or something like that, and you and your group are just kind of loud and maybe, catch the eye of an officer out there, you could get slapped with one of these charges. But to actually win the charge at a trial, they have to prove the case beyond reasonable doubt. And I'll tell you what happens most of the time in these cases is they do not do a full breath test or blood test to determine whether you're intoxicated. They also are kind of quick on the trigger on these. They are looking to make an arrest to shut down a potential problem more so than letting the crime finish, to arrest somebody after the crime's been committed. So we have a pretty good success rate in Montgomery County trying to get these taken care of. In a way where you can get the case expunged from your record later on. And that's what most people are looking for after you've been arrested. So what should you do if you do get arrested? If you do get arrested for public intoxication, the first thing I can tell you to do is remember that the police have a body camera that is probably right here on their chest, and they're going to be recording everything you say and do. So that is not the time to tell them things like, this is an illegal arrest, I'm going to have your job, or don't you have anything better to do, or things like that. What you want to do is be as polite as you possibly can and say as little as possible. Okay, anything you say can and will be used against you. That was the ruling of the Supreme Court in Miranda versus Arizona. You get read those rights for a reason, but the police is probably not going to read you any rights in this situation because they're not interested in talking to you once they've made the arrest. They're just going to make the arrest, put you in the back of the car, and if they are detaining you while they're trying to develop evidence, don't make a statement. Just tell the officer, anytime an officer's asking you questions, say, I want to talk to Brian Foley at Brian Foley Law PLLC first and get his opinion, because I'm going to tell you not to talk to him. There's very, very few situations. There are from time to time situations where I would sit down with you, with a police officer to talk, but almost never. Anyway, so you should remain polite and remain silent. So if he asks you what your name is during the booking process, you're going to have to give him the general information about yourself. They've already, they make most of these arrests as an on-site, on-view arrest, meaning the officer saw the conduct that he felt like warranted the arrest. The biggest one here that is the danger to yourself. That's what they're going to try to prove. So the less you say, the more opportunity you have to appear coherent and not out of it. and they would have to prove that you were so intoxicated that leaving you to fend for yourself, to try to get a cab, to try to get a ride, something like that, was actually dangerous for you. Okay, and here let's look at subsection A1 under the code, just so we're covering everything in the statute. For the purposes of this section, the premises located, a premises licensed or permitted under the Alcoholic Beverage Code is a public place. So remember how we said you go from inside the bar to outside the bar. They are typically going to wait for you to go outside the bar, but if it's a bar and it's been licensed by TABC, that is a public place. But subsection B, it's an affirmative defense to prosecution under this section that the alcohol or other substance was administered for therapeutic purposes and is part of the person's professional medical treatment by a licensed physician. Okay, so if you got prescription drugs that have put you in that position, then you can't get a public intoxication. But, that really rarely comes up. We're not normally dealing with that. And this is a Class C misdemeanor. It is not a lesser included offense of DWI. So for us defense attorneys who, would prefer to have a client convicted of this lesser offense instead of a DWI at trial, that provision there prevents us from requesting that in a jury instruction. Let's see what else we have here. I want to go over with you guys. Okay, so if you were arrested in the Woodlands, your case is going to get filed in JP3. And we have a certain period of time to send a representation letter to the judge in JP3. Now, if you end up hiring a defense attorney in Montgomery County for this type of case, we can go to court for you where you don't ever have to show up. We can work with the prosecutor, work with the court, get you some type of deal, hopefully get it dismissed for you. You can't ever guarantee any particular result in the case. We've got to look at the evidence in each one, but what we can do is give you an opportunity where you don't have to go to any of these court dates. We can handle all that stuff for you. So that is a really good feature of Class C offenses. But that does it. That is the skinny on public intoxication charges in Montgomery County, Texas. One other thing. Let me tell you one other thing. If you get arrested for this crime, you're going to go to the jail. You're going to be in there for a while. They're going to keep you in the drunk tank, or, it's a section in the jail for people to sober up in. And they're going to keep you there until you start displaying symptoms that you are not intoxicated to the jailers. And remember, the jailers weren't there when you got arrested. So they're going to be the ones judging that. Again, this is where saying as little as possible, but answering basic questions for the officers is going to go a long way. They are almost never going to obtain evidence at this point. They could obtain evidence. A statement you make to a jailer could be used against you at a trial, but it almost never is in Class C cases. The district attorney's office here in Montgomery County doesn't really have a way of collecting that evidence. So, okay, that is the skinny on public intoxication at the Woodlands Waterway in Montgomery County, Texas. Thanks.